That is Senator Kamala Harris talking about this Bob Mueller investigation and whether or not he spoke to anyone about it, a really important issue. And I want to bring in my very special guest for this morning. You saw him yesterday. He's back again. Former federal prosecutor, Gene Rossi. And Gene, I'm so happy to have you here because I know you have very strong opinions about the nominee. So I want to get started right there with what we saw. Do you think that that's fair, what he said? Look, I don't know everybody that works at this law firm, and we can't forget this is the law firm run by Mark Kasowitz, which is President Trump's former, I don't know if it's current, but former personal attorney. A really important question, but is it not, how does he know everybody that works there? What would you say to that?
Pitiful. What's ironic is this is the man who wanted to double down on the direct cross-examination of President Clinton before the grand jury when President Clinton testified. President Clinton gave answers that weren't the best. I got to tell you this. I had 110 federal trials. I supervised probably 400. And I saw defendants testify like Judge Kavanaugh. And let me tell you this. Kamala Harris's direct examination was outstanding because she was asking softball questions. And he couldn't answer a basic question. To whom did you talk at a certain law firm?
But how does he know?
He knows the answer. He knows who he talked to. I don't believe...
It's a big law firm, though.
I don't believe his answers one bit. And you could tell by his body language, he was trying to parse his answer. I got to tell you, that was pitiful.
But here's the thing. He's not a defendant. He is testifying, he is under oath, talking about being nominated to the Supreme Court. He can't give the same answers that a defendant would give in a criminal trial or a witness would give in a criminal trial. Isn't that fair?
I have to respectfully disagree with you. This is a trial in a way. It's a trial about judgment, integrity, and qualifications. His answers, the senators need to have fulsome and complete answers. Truthful answers. Because if you have a witness who's not truthful or complete or accurate, they should not be confirmed. And I got to tell you this, his testimony yesterday and what we're probably going to see today, if I were a United States Senator, whether a Democrat or Republican, I would be embarrassed that that person is answering the questions like that. You just look at his body language. Look at his eyes. He doesn't appear to be telling the truth. All he had to say was this, Jesse. I have talked to a lot of people. I probably talked to people in that firm.
Right.
I can't remember the specific conversations. I'm a citizen. I talk about public affairs, current events all the time. Have I talked about Robert Mueller? Of course I have. If he had said that, they would have moved on. Did you see the look on Senator Harris's face?
Oh, I saw it.
She couldn't believe it.
She was one of the great ones to watch throughout yesterday. But we talked about something yesterday, and I want to play it today. His involvement in the Bush administration's torture program became a big issue to talk about, as well as when he testified back in 2006 about his involvement. Let's play some of the clip right now of Senator Orrin Hatch asking him about that torture program. Take a look. That was a very important piece of testimony yesterday, and I want to talk about right now with Gene Rossi. Gene, you said that he lied to Congress back in 2006 and that he was not being truthful yesterday as well. That's a big statement to make. Are you saying that the risk of not telling the truth under oath, why not just tell the truth about the torture policies then? I'm not sure I understand it. He's really going to take that risk of not telling the truth?
Let me tell you this. The answer is yes. He has taken the risk. What does I was not read into the program mean? I don't know what that means. What he's referring to is he's not in a report or reports that have his name. Here's one thing that nobody's talking about and that the senators haven't brought up. There are 100,000 documents that haven't been turned over to the Senate. What are in those 100,000 documents? That's the first question. Number two, did the committees who did those reports or the Department of Justice, did they have access to those 100,000 documents? The answer is no. That phrase he used that in his practice sessions, I'm sure. I wasn't read into the program. What he's saying is, I don't have my fingerprint on a particular memo. I don't have my fingerprint in a report. That doesn't mean he wasn't involved. And it gets back, Jesse, to what I said yesterday. He was the smartest guy in the White House, and I can't believe that they didn't consult him in all those years about one of the biggest programs, controversial programs, in the Bush administration. It defies belief. Do I think he was misleading yesterday and in '06? Yes, I do. And here's what's going to happen. We're going to get memos in 5 to 10 years from FOIA, those 100,000 memos, and it's going to show that he was involved and he was more than just a passive participant.
Okay, we're going to talk more about that on the upside of this break because that's a very big claim. We'll be back here on Law and Crime. So stay tuned. There's a lot more we're covering. Okay, I'm back here with Gene Rossi. Gene, a common thread that we saw in his testimony was he said he would not touch upon issues that he's either not decided, that are political issues, or that issues that he thinks will come before his court if he's actually nominated to the Supreme Court. That seems like a fair answer if you are going to be in that nomination hearing about, I'm not going to answer these questions, it's not appropriate. What would you say?
Jesse, this may shock you. I'm going to defend Judge Kavanaugh on this. I was hard on him a couple minutes ago. I'm not bothered by his answer because you do want to be cautious. And Judge Kavanaugh is right. He does have a little leeway to make give some opinion on issues. But I'm going to defend Judge Kavanaugh on that answer because you don't want to get into a thicket of giving hypotheticals that you may have to change when you get on the court. So his answer on that question was appropriate. On the other ones,
I know it frustrated a lot of people. They wanted specific answers to these questions, but we kept hearing this phrase. He goes, judicial independence. I want to play you the testimony. I keep saying the testimony. I'm getting confused. We cover so many live trials. I want to play the question now from Senator Sheldon Whitehouse talking about executive privilege. Again, another hot button issue when we talk about President Trump. So what are Brett Kavanaugh's views on that? Take a look. Okay, that became another big issue in terms of all these documents and all these records and all these papers that they wanted in the Senate Judiciary Committee before they actually evaluate Brett Kavanaugh, and that they were denied these papers. I want to talk again with Gene Rossi about this. We talked a little bit about it yesterday. I want to talk about it again. Even if all the papers that are claimed to be part of executive privilege and were not handed over to the Senate Judiciary Committee, even if they got all those papers, realistically, practically, is that going to change the vote of any member of that committee?
Yes.
You believe that?
Absolutely. Those 100,000 documents, and first there were 3 privileges that were invoked. There was executive privilege, constitutional privilege, attorney-client privilege, and this vague thing that I used to deal with when I was a civil trial attorney for the Justice Department called deliberative process. They've invoked 3 of those, not on every document, but they've used it in some, or if not all, the documents. I think if they were provided the 100,000, yes, it would.
What's in the documents then? What do you think?
What's in the documents is his involvement in programs such as torture to show that he was read into the program. There is absolutely no way that he was not involved in the torture program. And in others, the other one he was involved in, and he kind of backtracked yesterday, was the warrantless surveillance.
So you're saying that it would give them and say, hey, look, you were not being truthful with the committee. That's what would change one of their votes. That's what you're saying, that exact point.
It would change a Republican vote, and it would embolden and affirm the decisions of the Democrats. And here's the other thing. It would push back the hearings beyond the November 6th election. And what happened yesterday was earth-shattering. We had the op-ed in the New York Times, and what you have now is this cloud over the presidency because an anonymous senior aide in the White House says that the president is unstable and he's nominated this individual.
What would you say to the argument that they have all of his opinions to look at? If they're going to nominate him as a Supreme Court justice, that's all you have to look at?
No. You have to look at qualifications, integrity, and judgment. And I agree that his 12 years on the D.C. Circuit, I am not going to attack him on that. Do I agree with all of his opinions? No. But I have no reason to doubt his integrity in deciding those cases. I question his judgment. But when you're going before the Supreme Court and being confirmed, you have to look at his whole life. And you have to look, what did he do before then? He was a political animal. He was a political animal. He worked for Ken Starr. Then he was the gopher, if you will, for Karl Rove. And he was involved in politics. I don't want to judge who has a background like that, and I don't want to judge who doesn't is not truthful on all the decisions he made in his life. He shouldn't be on the Supreme Court.
Well, Gene, you are speaking about the exact criticisms that people have of Brett Kavanaugh. When we come back, we are going to continue playing you some of the heated exchange from yesterday's testimony. We'll be back. What role did this organization, the Federalist Society, have in Brett Kavanaugh's nomination? We're going to talk about that right now. Do want to preview, though. We have a live feed in the Senate Judiciary Committee. Nothing is happening quite yet. We'll jump there in a little bit, but you know we're going to be live there today, and we have so much to talk about. But I want to bring back in Gene Rossi. Gene, what is the importance of whether or not the Federalist Society helped to get this nomination underway? Why do we care about that from the viewers?
I don't want to say anything disrespectful to the Democratic senators. I think this is a nothing burger. Here's why. Every party has groups that they get advice from. And I got to defend Judge Kavanaugh on this. I've been hard on him. But on this issue, the Federalist Society, I trained about 1,000 prosecutors. Most of them were probably Republicans. And when I got their resumes as baby prosecutors, they had the Federalist Society. One of them is the chief counsel, the judge, to Chuck Grassley. And I don't think there's anything inappropriate for the Federalist Society or any group on the Democratic side. It could be the NAACP, the Urban League, for those groups to give their advice and opinion on the proper process or recommendation for a nominee. I don't see anything wrong with that, as long as they're not the deciders and they're just advisors. I think that's just politics 101. And so I'm going to defend Judge Kavanaugh. And if you look at his body language, he was pretty relaxed because he knows this is not an issue that's going to tube his nomination. So my answer to your question is, I don't think there's anything inappropriate for the Federalist Society to opine to Republican leaders, hey, we think this nominee's good. I don't think it's inappropriate for Democrats to get the same advice from certain groups. It happens all the time.
Before we go live, I gotta ask you one more question about this, and I'm sorry that we're going here, but when you say that he was not being truthful, I still can't grasp the concept. The idea that a sitting judge, a nominee for the Supreme Court, and you say that he is not being truthful about his record with the Bush administration's torture policies and that he misled Congress in 2006 and he's misleading Congress again. I don't believe that. I can't believe that someone would do that. And it doesn't seem palpable that all those documents that we're talking about are somehow shadily hiding this information. Isn't it just documents that, hey, it's a part of privilege? He worked at the White House. It doesn't make sense from a practical point of view that this kind of nominee who has been regarded very highly in the legal community would lie under oath. So what would you say to that?
Let me tell you why you are wrong, sir, with all due respect. If Brett Kavanaugh did not have his name on any of those 100,000 documents that related to torture, you would guarantee that the White House would issue a press release in saying, we've reviewed the 100,000 documents, we still think they're privileged under executive, attorney, or deliberative, but we can tell you this. His name, he is not copied or listed in any memo relating to the torture program. Has the White House done that? No. And the reason is his name is in important memos. And I got to tell you this.
But you're assuming that. You're assuming that.
I'm assuming that based on my 30 years as a prosecutor. I can smell a problem, and I can smell an inconsistency, and I look at his body language, and when he's answering that, you could tell he's grabbing.
He could be uncomfortable being there in front of millions of people watching this, but we'll have to talk more about his body language.
I respectfully disagree on that one.
Okay, we'll have to talk more about it. We have to go live, though, because the Senate Judiciary Committee is underway. Day 3 in the Brett Kavanaugh nomination hearing. Let's go live. Do we ever have a day that it's not explosive in this hearing? Oh, my gosh, Gene, that is a bombshell, what Cory Booker just said. He said, I am going to knowingly violate the Senate rules, release this email that should not be released because I want full transparency about this candidate, and I don't care if I get kicked out of the Senate. What do you make of this?
If that's not on the front page of the New York Times tomorrow, I don't know what will. I am shocked. What he's doing is, and Bear in mind, he is running for president, so this could be part of that, because you always have to look at motives. But I think Cory Booker is outraged, and he's saying, you know what? These rules are terrible. They're too partisan. This is a Supreme Court nominee that's incredibly important that we should consider. And I'm going to risk my Senate career by breaking the rules. And I got to give Cory Booker credit, okay? Unlike what I said about Judge Kavanaugh. He is being very honest on he is going to willfully violate.
Does he mean that, though? I mean, how much is it? He knows the cameras are watching, and he knows his voters
Well, that's what
are
I said.
watching.
He's running for president. But I believe that he's going to release the email. He's telling him I'm doing it willfully, and make my day and censor me, if not oust me. That's unbelievable. I've never seen that at a hearing, because the Senate is the model of decorum. And Senator Cornyn's right. The Senate is a little different than the House. But he's basically saying, make my day. Bring it on. This is unbelievable.
I don't care which way you fall on Brett Kavanaugh. This is definitely something that you have to watch. This is groundbreaking. And I don't know if I've ever seen a confirmation hearing quite like this before. But we will have a lot more. We have to take a quick break. When we come back, we will be live back in the Senate Judiciary Committee. Stay tuned here on Law&Crime. Okay, so what's going on right now is that there were thousands of documents that a lawyer for President George W. Bush turned over to the Senate Judiciary Committee about Brett Kavanaugh. They were deemed committee confidential. That's a whole discussion right there between the senators about why it was deemed that, who is it appropriate to deem something committee confidential. If something's deemed committee confidential, it means that it can't be made public or discussed in an open forum by any of the senators there, but they can consult with it and discuss it amongst themselves. But you hear many of the senators saying that the public has a right to know about this candidate and that there's a general discussion about it. I want to bring in Gene Rossi to talk about it. So we're talking about all the secretive nature. Let's break down what some of the content is. Right. I want to read you some of the emails. In one, Judge Kavanaugh was considering a draft opinion piece in terms of that would go towards people that were anti-abortion. There was a line that he wanted to delete, and he proposed instead saying, I am not sure that all legal scholars refer to Roe v. Wade as the settled law of the land at the Supreme Court level, since the court can always overrule its precedent, and there are already 3 current justices on the court that would do so. Now, he didn't say his particular view on Roe v. Wade, so in one sense, why is that even a big deal? I mean, isn't he just stating something from a legal opinion?
It is a big deal because that is a window into his soul, if you will. When he wrote that draft or made that suggestion, he's basically given his personal opinion that if I were a judge, this is how I would rule. And now he's backing away. I want to address the document.
Is that fair, though, that he's really saying it's his opinion? He's just saying it might not be considered a well-settled rule under the land if you look at what the Supreme Court makeup is.
When he was in the White House counsel's office, whenever he put a suggestion in a memo, it was his view. He didn't put it's someone else's view. That's his view. And at the time, what he wrote was accurate. But, Jesse, I got to talk about the documents. We have, according to my arithmetic, the Senate has only gotten 7% of his White House documents. And of that 7%, only 4% of the 7% has been disclosed to the public. So the public has only seen, if my arithmetic is right, 0.0028% of the White House documents of Brett Kavanaugh. That's disgraceful. That is disgraceful. We don't know who he is.
But you were assuming then, and I know we don't have much time, that he is going to make a decision as the Supreme Court based upon his personal views and not what the law says. I know we only have 15 seconds. Is that what you're saying?
I'm saying it's not his personal views. It's his personal views of what the law suggests and provides. I now believe, based on that email, that if he gets on the Supreme Court, I said yesterday he would chisel. I now think he would take a sledgehammer to Roe v. Wade. Based on that memo, he would overrule Roe v. Wade. Yesterday, I thought he would just chisel it. He's going to take a sledgehammer to it.
Okay, that's a great statement to end on, a very big statement to end on. We have a lot to talk about. We have to go to a break, but when we come back, we're going to go live and we're going to analyze. A lot to talk about here on Law and Crime. Exciting day. We're talking about all these documents that the committee either should see, has a right to see, that the public has a right to see, should see. Want to bring back in Gene Rossi to talk about this. Senator Lee made an interesting point that under the Presidential Records Act, if you have a problem with the release of all these documents, it's a problem with the act. It's a problem with the legislation. We do not have a right to present these documents, and they are classified committee confidential for a reason. What would you say to that argument?
I don't know if I agree with Senator Lee's analysis of the Presidential Records Act, number one. And number two, from my understanding is the National Archives has to get involved in the process. And Bill Burke is an outstanding attorney with a fantastic firm, Quinn Emanuel, and I don't doubt his integrity. What has happened and what troubles me greatly is he is a dear, dear friend of Judge Kavanaugh. And Judge Kavanaugh, I think, maybe supervised him or they worked together. There is an actual and apparent conflict of interest when you have Bill Burke, who has a tremendous integrity and a reputation nationally, to reviewing all these documents. I don't think the Presidential Records Act was intended or approves the process that they're using now in having Mr. Burke be the decider. And here's a proposal that maybe the senators will listen to your show. They should get a well-respected Republican, a well-respected Democrat to act as co-masters and go through the 99% of the documents that are withheld to determine if there are privileges involved, get a report out in 2 weeks. They can do it quickly, and then we could have the hearings probably the end of September. I think this is becoming a food fight. Now, I got to talk about Senator Booker. I thought he was violating a well-established Senate rule. He's violating what I call a chairman's rule. So it's still a gutsy thing that he's doing, bold, but it's not like he's violating a Senate rule. He's violating Senator Grassley's rule.
Yeah, he really loves talking about how he's been violating the rules, and if he gets kicked out of the Senate, that's what it is. When we come back, I'm going to talk about the next email that was released about Judge Kavanaugh talking about the Department of Transportation's affirmative action regulations. Definitely want to pay attention to this, and we'll analyze it when we get back. Stay tuned here on Law&Crime. Welcome back, everybody. We are talking about the Brett Kavanaugh confirmation process, the nomination hearing in the Senate Judiciary Committee. The questioning hasn't even begun today because they are talking about a bombshell new report from the New York Times that just happened, where they're talking about a release of all these documents that were handed by a lawyer for George W. Bush. And it has a series of emails from Brett Kavanaugh about his legal opinions, his legal views at the time when he worked for the Bush administration about such issues as abortion and affirmative action. And the question is, should these documents be released to the public? Should they be discussed in this open forum? I'm here with Gene Rossi. Before we go live, Gene, I'm not sure I understand what the whole bombshell situation is in the sense, why does this even matter? One of the emails in question, which is, again, reported by the New York Times, is that Judge Kavanaugh expressed a somewhat critical view about the Department of Transportation's affirmative action regulations. I want to read it to you now. This is Judge Kavanaugh. The fundamental problem in this case is that DOT regulations use a lot of legalisms and disguise to mask what is a naked racial set-aside. He added that he believed that 4 of the court's conservative justices, meaning the Supreme Court, would realize as much in short order and rule accordingly. So even if we get all these documents, even if we get all these emails, if this is what the emails are like, what have we learned about Judge Kavanaugh that's really that significant?
Well, first off, William Faulkner said the past is prologue, and what you say or do in the past is a good indicator of what you're going to do in the future. That's an indicator to me that if he gets on the Supreme Court, he is going to get rid of set-asides. He could possibly get rid of any cases or overrule any cases involving affirmative action. And the goal of diversity at the higher education level could be at risk given his views on the Department of Transportation. I think that email is a big deal.
But can't you argue that he was just analyzing what the current makeup of the court was there, what the law was, and that him as a judge is a completely different role than what he wrote that email back in almost 15 years ago?
I think it's a mixture of both. He's analyzing the law, observing that there's an opportunity to do certain things, and from reading that email, he agrees with that position. That's the way I read that email.
Okay, we're going to learn more about the emails in a minute. We want to go live right now. This is a really exciting day. Day 3, it just keeps getting better and better and better. Let's go live. Welcome back, everybody. So we're obviously following the Brett Kavanaugh confirmation hearing, and I love that little bit about whether or not cameras should be allowed in the courtroom. We obviously want cameras in every courtroom. But now I want to let you know that if you want to follow the Stanley Liggins case, you can go to lawandcrime.com. It's live right now. But we want to focus on Kavanaugh. I'm here with Gene Rossi to talk more about it. Gene, before our next break, there was an interesting back and forth there about executive privilege and how Mr. Kavanaugh, on different occasions, ruled against the president that it actually appointed him to the D.C. Circuit, which would indicate judicial independence. We kept hearing this from Kavanaugh. Your opinion, you believe that he can be independent from the views that he maybe expressed in the past?
I think that's a very strong point in favor of his confirmation. And the 12 years he was on the D.C. Circuit, including those decisions he made, those are the issues that they should stress. And so I got to compliment Judge Kavanaugh on his decisions in those cases. But that still does.
Well, the one that you really had an issue was with the Roe v. Wade, because we talked about earlier an email was released where he suggested that perhaps it's not settled it's not settled law in the land that Roe v. Wade is the law of the land, that perhaps it could be overturned.
Sure.
You said that statement would give you pause to think that he would overturn Roe v. Wade. That's a big statement to make, though, just because he made that statement back in the day.
Well, it's not a big statement to make. Humbly, I say it is not. Let's go to the Federalist Society. At their seminars, at their organizational meetings, they're always talking about how if we get the right Supreme Court nominees and the right justices on the Supreme Court, there's no reason why Roe v. Wade cannot be overturned. I believe that Judge Kavanaugh has bought into that, and that email is that document you just referred to, that is a red flag and loud gong that if he gets on the Supreme Court, he will be very inclined to overrule Roe. I really believe that.
But you need the right issue. You need the support of the other justices. It might be too quick to say that, but we'll have to see. We're going to take a quick break on our end. We'll be right back. Stay tuned. And welcome back, everybody. So we are going to analyze the last bit of this testimony right now. I'm here with Gene Rossi. I have to sign him off in a little bit, but I'm just going to go point blank right now. Do you think that Brett Kavanaugh is qualified to be the next Associate Justice of the Supreme Court?
As I said yesterday, there are 3 categories you look at. Resume and CV. Yes, he's qualified under that test. Number 2 is his integrity. And based on his what I consider misleading answers, he's failed that test. And number 3, based on his judgment on some of those answers, including his failure to really give a good answer on was Roe v. Wade correctly decided, he didn't answer that.
But isn't it not appropriate for him to make a decision on any case right now? Every fact, every case, every situation is different, and he is going to judge that appropriately when that case comes to him. Isn't it not fair for him to make a decision right now or a statement right now on any kind of position?
If he was asked if Brown versus Board of Education was correctly decided, he would say yes. If he was asked if Miranda was correctly decided, he would have said yes.
Can't you say those issues are not going to come up for the court, but Roe v. Wade could? Something like that?
Miranda issues come to the Supreme Court all the time. Education issues come to the Supreme Court all the time. So if he's able to answer on Brown versus Board, on Miranda, on other issues, there's no way he could not answer the question, was Roe v. Wade correctly decided? He couldn't answer that question.
And do you think he's going to be confirmed?
Yes, he will.
You do? Despite all the records and all that stuff.
Over my objection, he'll be confirmed.
Well, Gene, listen, it was great having you on, and I loved having your perspective. You need to come back, okay? Pleasure as always. Thank you. We are going to take a quick break on our end. When we come back, it's all Brett Kavanaugh. Stay tuned.